to discuss very interesting matters bordering on the law every Tuesdays and Thursdays on Star Television, Channel 21 with Abdul Rahman Kamara.
Sierra Leone needs to ensure that we have a level playing field. Women are underrepresented in politics, so it is not new.
What's at stake is the right to vote and be voted for.
In addressing these issues, we need to be very careful.
For many years, Sierra Leoneans have suffered from countless cases of injustice and subjected to some form of prolonged justice system in the country due to litigation congestion. Familiarize with the Law provides the platform for more inclusive and detailed analysis by legal experts to unravel the nuances bordering on legal matters. Join Abdul Rahman Kamara every Tuesdays and Thursdays 5 p.m.
Pleasant good evening to all of you. This is Star Television, broadcasting live from Media Center 3 Mama Street, Brookfield in Freetown. My name is Abdul Rahman Kamara. The Sierra Leone Bar Association, in a press release dated 6th May 2019, says there have been following reports of forcible repossession of land purportedly deemed to be state land. A number of accounts noted that officials of the Ministry of Lands, including the Minister of Lands, supported by armed military personnel and police officers, have entered a number of pieces or parcel of land and have forcibly possessed the same. It's against this backdrop that to help me take the discussion further, I have not as a person, the public relation officer for the Sierra Leone Bar Association, lawyer Israel Jah. Welcome to the program.
Thanks for having me.
First of all, how did you come to having a press release issued?
Well, this is not a press release. This is a letter written by the president of the Bar Association to the director of lands, surveys, lands, and the environment. The letter has its origin in the spate of the series of land reclamation, repossession, especially state land or government or public lands. And the Bar Association is concerned that in as much as the minister is doing his job or is very passionate he's doing his job, yet the job or the performance of his job should be within the ambit of the law. So as you are aware, Bar Association always stands with the people of Sierra Leone, always ensure that the rule of law is adhered to, that policies are made in the best interest of the people. Therefore, with the several spate of complaints, several spate of incidences of house breaking, of forceful repossession and reclamation of purported state land and so on and so forth, the Bar Association deemed it necessary to bring to the attention of the Director of Lands and Surveys several issues, among which are the laws which you have to comply with in order for a government agency's department and or a minister to carry out such forceful reclamation or repossession of purported state lands or public lands.
Israel Jah, under which circumstances does the Ministry of Lands will have the mandate to embark on repossession?
Now, this is very clear. By the Crown Lands Act of 1960, the government or the ministry, through the government of Sierra Leone, would, as you normally know, people would apply for lease of state land. Of course, the land is vested in the government. That's why we have crown lands or public lands. Now, due to the nature of our land tenure system, in our land tenure system, we have what we call duality of tenure system. We have the English law system and the customary law system. So what you have in the province, in Freetown and its environments, which we used to call a protectorate, is where the English law system applies. Whilst in the provinces, is where you have the customary law. Customary law applies.
What we used to call a hinterland.
Hinterland, as you would say. Now, what happened is that people would usually apply for lease of state and government land, and then the minister the ministry through the minister would give access or grant leases to people on certain conditions, among which you have to develop the land within a specific period of time. You have to pay lease rent, and if you do not pay this lease rent, or you do not develop this piece of land that has been leased to you, then government can reclaim it. Also, we are very aware, and I am also aware, that there are series of squatters on government land. And over the years, and especially during the previous regime, there were too many possession of state land. Some were done legally, others were done illegally. And so, by virtue of the Lands Act, the government and the minister can reclaim state land. However, our concern is, by so doing, a man can carry out a lawful duty, but you can do it in an unlawful way or in an unlawful manner. And if it is done so, then you have not done the right thing.
In your letter, you reiterated that the laws relating to repossession of land and state acquisition of land are very clear.
Yes.
And that the action undertaken by the ministry in the view of the bar have not deemed it fit to follow the provision of the law and are not sought a court order for repossession. A declaration from the court that the land being repossessed belonged to the state, or any other declaration of relief from the court. Does it require a kind of court order in a situation where you have the conviction that this particular land is a state land and its acquisition is pretty much illegal?
Yes, in fact, that's the thrust of our letter. That's what forms the core of the letter. Now, we have no problem in the responsibilities
of the ministry
and the way the minister tends to carry out it. We have the problem in the manner in which it is done. Now, by Section 30, subsection 1 of the Crown's Land Act 1960 as amended, clearly states who and how repossession or reclamation of state land or public land can be done. It is very clear. It states, in fact, the law is that it's not even the minister. It's either the AG, which, as you are aware, the AG's office, the Attorney General's office, is the principal advisor to government. Mm-hmm. So if any ministry, department, or agency wants to do anything that has to do with the law or the court, they have to approach the AG's office to do the necessaries. And that's what the law says. And secondly, most importantly, it's not the minister. It's either the AG or the deputy or the director of lands, who should, where he feels that people who have occupied state land have occupied it illegally, or were licensees in the first place, who at the end of who by virtue of their act or one way or the other their license have expired, or were squatters or illegal occupiers, then you can go to court. And then the court, which is an independent arbiter, and the judge who sits, that has no interest in both matters or interest in either of the parties, will decide the matters. One, they would have to investigate titles. Two, they would have to investigate how the land was acquired. Mm-hmm. Three, they will have to investigate whether or not indeed the land is state land. So there are laws governing this. Hence we are saying, as you are aware, it has been over the media that there have been police brutalization. There have been the minister carrying out his functions with the assistance of military men, which is very intimidating. And so many things. There have been issues of outcries of rape, molestation, harassment, and so on and so forth. We are saying that the minister has his mandate, and he perhaps is very passionate to do his job. But let it be done within the ambit of the law, as prescribed by Section 30, subsection 1 of the Crown's Lands Act.
And the wider implication in a situation where he doesn't follow the right procedure, getting a court order before demolition or repossession.
Well, that's the problem. Now, nobody is above the law. The law is supreme. you may or may not know that there is a national, a proposed or national state land policy. This land policy tells you where and how amendments should be made to our land regime and regulation. So the minister has his own function, which I believe is carrying it out. It is within his mandate. But the mannerism is what we are concerned about. Now, land right is a fundamental human right. Imagine situations where a man has worked all his life and saved his earnings to build a house. And all of a sudden, that house or land is in question as it's a state land. And all of a sudden, the minister or whosoever, his workmen or agents or privies or his agent, will just get up one day and go and demolish such a structure. One, you have caused unnecessary harm and danger and even psychological damage to that person. You may have created insecurity and instability in the environment. And we are very conscious that land issue in Freetown in particular has been very tumultuous, is not an issue people joke with. In fact, we remember that in those days there was this killing of one Mr. Moore from the Lands Ministry. So these are things that does not bode well with people. And also importantly, this issue of land creates political instability, creates destabilization. Because with the way it is being done currently, it might even incite public disaffection and ill towards the government. So we are concerned as well, I want to use the word moral guarantors because bar association can be considered as a CSO or a pressure group. As moral guarantors, we cannot let the state of affairs degenerate into a further chaos as more than what it is. So therefore we are saying that you cannot, the minister cannot, we have not heard of any court case in which an action instituted by the minister to recover state land. We have not. He's not gone to court for declaration of title. He's not gone to court on other issues that will say, okay, I have a court order. The court orders that you should vacate this property. You understand? We agree. There are people who are illegally occupying state land. There are people who have acquired state land illegally. There are people who have defect title to state land. Those are issues that are very common. And mind you also that these people do not only get up one day and got these lands by themselves. They may have gone through officials at the Ministry of Lands. And we know that over the years there have been this rampant corruption in the Ministry of Lands and Environment. There have been sale and repossession, lease of state land to several people, and so on and so forth. So you can see the kind of turbulence, the kind of thing that is going on. So hence we are arguing, even for the safety of the minister, for the peace and security of the state, for the well-being of all Sierra Leoneans, when you want to do reclamation of land or repossession of purported state land, you have to get a court order. That's what the law is.
Well, perhaps this might sound a little bit confusing when you look at the current trend of activities undertaken by the Ministry of Lands. One will be holding the impression that in as much as it is a repossession, it may equally be seen as a kind of a compulsory acquisition of land. Could that be the same?
No, compulsory acquisition is not, in this circumstance, not compulsory acquisition.
It is not.
It is not. In certain circumstances,
yes,
this is, well, you can tell from the minister's several public statements and press releases and letters. And then the social media exchanges of words and letters, back and forth correspondences between him and some lawyers and some segments of society condemning his actions. Okay, we are saying that when it comes to the issue of public compulsory acquisition, the law is also very clear. Now, compulsory acquisition is a situation where government would have to take land from individuals
for development
purposes.
Yes.
For development purposes.
It might be road construction.
Yes, it might be anything that is necessary and good for the development of the country.
Okay.
But however, when the government is doing compulsory acquisition, government would have to compensate the landowners.
Adequate compensation.
Adequate compensation. In fact, the law empowers the owners of those lands
To
to
even
go to court.
to challenge.
Yes, to
if
go
the
to court.
compensation is not adequate.
It's not adequate, exactly.
Yeah.
So you see, in such a situation, one can argue safely that that's not a compulsory acquisition. And there is no memo or anything to the effect to show that it is compulsory acquisition.
Okay.
What we are seeing and what is happening is forceful repossession and reclamation of state or public lands. We are saying, in as much as the law allows the minister to do so, you have to do it within the ambit of the law. You cannot just wake up one day and decide to break people's houses just because you are claiming state land. You cannot just wake up one day and decide to evict the whole of certain residents of a particular piece or parcel of land just because you feel that was state land. Yes, indeed, people, we do condemn. The Bar Association condemns the illegal occupation of state land. The Bar Association condemns the squatters on state land. We actually agree with that. But however, the law is there to protect the rights of individuals to land. It is their right. In fact, it is a human right. In fact, by section 20, I think it's 20, chapter 3 of our Constitution on the Fundamental Human Rights, right to property. Mm-hmm. Nobody, not even the government, can deprive you, except in certain circumstances, for example, in public emergency, public health, and those sort of circumstances. You understand? Your rights can be abrogated. But as we clearly see, such circumstances have not arisen. So we have to be very careful, and the minister has to be very conscious in the way he discharges his duties.
Perhaps this could be different from your letter you've written to the permanent secretary in the Ministry of Lands. This is a press release dated the 2nd of May 2019. Reaction of descendants of settlers on the land issue taking place in Western area. I read verbatim. We, descendants of the 4 homogeneous groups, Nova Scotians, Maroons, liberated and Paul Kufi returnees, are naturally perturbed, dismayed and shocked by the official statement of the Honorable Minister of Lands, Housing and Environment, reported on the media on the 26th and 27th of March and 28th April 2019. Also, the subsequent action of dispossessing the rightful owners without due process of the law. These owners, as the record will prove, have been in uninterrupted possession over 3 or 4 generations. For the record, it is important to name some of the dispossessed locations: Polu, Number 2 River, Black Johnson Village, King Street, Levuma, Regent Village. Lately, the Permanent Secretary of the Ministry of Land, Housing and Environment, Mr. Israel B.K. Jiba, copying the Attorney General and Minister of Justice, Chief Justice and Minister of Land, Housing and Environment, directed owners of constructed houses to forward all land documents for Masimbo and Regent area to the Minister of Lands, Housing and Environment latest on 21st of May 2019, failing which there will be no redress. It is with utmost disappointment that we heard from the state opening of the 2nd session of the 5th Republic, where addressed by His Excellency the President on the 2nd May 2019, the corroborated statement of the dispossession of land in the Western area. All descendants of Creole here and the diaspora are herewith alerted about the current dangerous trend in the Western area concerning the ownership of the land and the violation of their right ownership. The entire caucus of the Creole descendants. End of this press release. I come back to you. What, in the view of the Bar Association, you find that are pretty much difficult for the minister to actually go and secure the right order in the court before embarking on the current trend that is doing now, repossession of land? Why do you think he's finding it extremely difficult? Maybe he knew what he's doing is right, except otherwise.
Well, I cannot say that the minister is finding it difficult, because I'm not aware that he has or has not approached the court to get court orders to do this eviction or reclamation or repossession. I am not aware. It is our belief, our honest belief, that he has not sought a court order to effect such reclamation or repossession. Now, the press release you just read by the Creole Descendants Association, the Bar Association stands with the law. And these people, the Creole Descendants Association, believes that they are the original owners of the land. So perhaps it can be considered, in that aspect, it can be considered as private land, depending on which angle of the argument you are.
Okay.
Now, what we are concerned about, and for which I'll have to speak, is that the Bar Association is really concerned with the mannerism in which this process is going on. Mind you, we are not saying the minister is wrong in doing what he is doing, in carrying out his function. We are not saying perhaps it is government policies that the minister reclaims state land or public land. We are saying, in as much as you may have a legal duty to perform, yet if you perform such legal duty in an illegal manner, then you will achieve no result. Because what at the end of the day you want to really achieve? Because you cannot say you want to take a certain person to the hospital, and on your way going, no matter the pedestrian you see, you ride over them, killing them on the spot, just because you want to save a single life. So this is what we are saying. Some people, in as much I have told you this, and this is our position, there are people who may have illegally acquired state land. There are people who are clearly squatters. There are people whose license or whose leases have expired. There are people who have gone through the back door, especially through ministry officials, to acquire land, or use political offices to even acquire land. However, in order to establish that
this is the case.
Yes, this is the case, or their right to that land was illegal, it is only a court of competent jurisdiction that has the power to determine that. It does not lie within the power of the minister to do that. So hence, his forcible reclamation or repossession of state land is illegal until he sorts or gets a court order to do so.
I bring the question again. Is there any express provision for a personal lawsuit taken against the action of the minister?
Yes, of course. In fact, as we speak, there are myriads of cases against the minister, including complaints against him in the Anti-Corruption Commission and several others. He has several cases with lawyers as well. So, yes, this is what we are saying. Whether you are a minister or an ordinary man, no man is above the law. The law reigns supreme in the country. So, it matters how...
Can the Bar Association challenge this matter to court?
Yes, that would be a last resort. If we think... Because the letter we wrote to the permanent secretary is to caution him as to how these activities are conducted.
And maybe this is the reason why...
Now, please let me land.
Okay.
I mentioned in section 30 of the act I cited that it is not even the Minister of Land who has to institute an action in a court of law to reclaim or repossess state land. It is either
it
is either the AG or the director in the lands ministry. So these are the people who the law authorized to take. You understand? And if you get a court order and the order dictate that such demolition should be carried out or reclamation of the person, then the minister has right to go there. You can also remember that I think the chairman of the Parliamentary Committee on Lands even gave a memo or gave a notice that policemen should not accompany the minister and his henchmen or other people to go to whilst they are on a spree of demolition or reclamation of land. Because even the mere presence of military personnel, the presence of police officers is intimidating, or policemen, it's intimidating. And the state, by section I think it's section 6 of our constitution, 1991 constitution, it is the state's duty to protect the individual and to ensure that the rule of law is followed. You understand? That's what our constitution says. So the individual, you and I as individual, we have rights to land. It is our inherent human right. By virtue of our birth in Sierra Leone, by virtue of the fact that we may have purchased those lands. And I mentioned it earlier that several people have complained, and most of us who are lawyers have gone through that system, that some ministry officials will send a single piece of property or land to one or two people to one or two purchasers. At the end of the day, what do you expect? You expect skirmishes and clash. So the minister, in as much as some of us see that he's very passionate in perhaps carrying out His Excellency's directives, if it is, to reclaim public land and so on and so forth, we are saying that he can approach the AG's office, the law officers department, to do the necessaries. It does not cost him anything. Most importantly, we just have recent addition to the divisions of the High Court. So the Chief Justice has just passed. There's a new statutory instrument on that issue. So if actually that's what the minister is intending to do, they would have made a fast-track land court to handle these things. It would have been easy, so that people at the end of the day, because now this is also my argument. You cannot address issues that has legal basis with a political wand. Because at the end of the day, let's say now the SLPP government is in power. So let's say 10 or 20 years from now, another government takes over. That same issue will be reversed. You remember when the minister came, his first ministerial order or decree or something was to cancel all deeds.
Ministerial order number 1.
Exactly. So we are saying a government is an issue, is a matter of continuity.
Continuity.
Yes. So a minister in the Ministry of Lands has the same power. A predecessor minister has the same power as the current minister to have issued title deeds, lease land to interested citizens who may have acquired it legally as well, so and so forth. So we are concerned that when this is done, the only way we can know that there is a permanent solution to these issues is when you get a court order. Because it will let the matter to rest. Even the aggrieved citizen or the person who you are challenging that he or she has no right to be on that land will feel that he has been given due access to the court.
But the expectation here by members of the lay public is for the Attorney General and Minister of Justice as the legal advisor to His Excellency to actually advise appropriately on the current trend of activity. Otherwise, in a situation where things boomerang, it will have a kind of wider implication. But over and above, I'm looking at the point where perhaps what he's trying to prove, I'm honestly not thinking for the minister. What he's trying to prove, we've seen situations where many families do acquire property without documenting their lineal transfer of ownership. Otherwise, they rely on much more on what you lawyers refer to as parole evidence. In Papa Binde, as witness, we bingi this particular land without proper documentation. So this is practically what perhaps the minister is trying to get a certain to and make a repossession. But as you rightly said, you do not care much more about his job, his exuberance to actually carry out his function, but the manner in which it is done without deriving the authority from the courts.
Yes. And you raised some important issues. Number one, is it the duty of the Attorney General and Minister of Justice to advise the government on this current issue? Yes. Number two, did the minister seek the advice of the AG's office to do what he is doing? I wouldn't know and I wouldn't tell. As far as we are concerned, we have not seen anything of that sort. Or else, if there were advice or if he was advised to do otherwise, then perhaps the appropriate measures would have been taken, would have been put in place.
So in your belief, if the Attorney General, I assume, would have advised the Minister of Lands to carry on this particular trend, her advice would have been, go to the court, derive your authority, and embark on what you're doing. Is that the case?
But that's the law. I believe it would have been an advice, except otherwise.
Yes.
I believe that's the law, because no ministerial order, no policy of any sort overrides the law. The law is the law. The law is supreme. Nobody is above the law. So until the law is amended and then the necessary action is taken, we stick by the old law. 1960 Land Ordinance Act, Crown Land Ordinance Act is very old though, but that's the law we have. We have to make do for now with. So there's nothing we can do about it. So I believe that if the minister sought the advice of the Attorney General and Minister of Justice, then probably he may not have been acting the way he is acting. Or perhaps there is some lack of communication. Or perhaps there was the advice or nobody paid heed to it. So these are the things we are concerned about. And indeed, you raise a very important thing. And as I have told you inter earlier, that we do acknowledge the fact that, of course, there is land grabbing in Freetown. This has been on since the end of the war. People have been grabbing lands everywhere. In fact, state lands. Now we think about Guma, even Guma's catchment area has been encroached upon. All government spaces, including Frobe College, and those, even onto Parliament's land, people are encroaching. It's very bad. Land grabbing is very bad. Nobody condones that, not even the Bar Association. So we are not saying the minister is not doing the right thing as far as reclamation of state land is doing. We are worried about the manner in which it is being conducted. Yes, you also mentioned the issue of people coming with parole evidence to say, this is my grandfather's land, I have acquired this land. In fact, most lawyers have been doing statutory declarations of title for a very long time. Indeed, for those of us who do conveyance, lawyers will say that you have what they call root of title. How did you get this land? The chain of conveyance of this land to you. So people over the years, just because they have been farming on a certain piece and parcel of land, at the end of the day they will claim that land, irrespective of the fact is whether it's government land or not. So that has been the trend. Yes, we do see that every now and then. But however, in order to ascertain that the present occupier of that land is a squatter or is an illegal occupant, you must have to investigate his title. And no better person is placed or institution is placed to do that than the courts. Therefore, we say that the courts, in order to enforce this reclamation or repossession, you must get an order of court. It is very important. For instance, even as a landlord, you just cannot throw your tenant out. You will not just get up one day and say, for instance, the tenant is not paying house rent, or he's been abusing me, or we've not been having peace in our home, I'm going to throw your things out. When it takes you to court, the law, they will claim you for damages.
Maybe
these are the things we are concerned about.
This is not a thinking. It's not actually the thinking of the Bar Association, but I believe the action of the Minister of Lands, Dr. Dennis Sandi, is becoming pretty much emboldened, judging from the corroborative statement by no less a person, His Excellency, during the nation-state address, where he reiterated the point that as part of their party manifesto, they're now working towards fulfilling one of their critical promises on land reclamation and land repossession. So, in the views of many people, that could be one of the many ways that is keeping the minister to go the way he is going, because he has got it from his boss. He was in Parliament, His Excellency was in Parliament, and he said his words. So, who is Dr. Sandi not to actually execute and take the trend that is following? This is public knowledge now.
But yes, the president may have said that. It is
on the belief
state
on the
policy.
belief that the law should be respected.
Of course. But of course. I mean, government has their own policy. Every government has its own policy. So,
again, is it difficult for the Bar Association to actually have a closed-door meeting with His Excellency as a moral guarantor to actually tell him the wider implication should this policy of the minister unilaterally do, disregarding the rules of the court, not obtaining court order to do what he's doing, and advise adequately His Excellency that, look, if this particular trend continues this way, the implication will be pretty much huge. Do you have the leverage to actually meet His Excellency and talk to him as a body of lawyers?
Yes, the Bar Association can approach the president any time on any issues of national importance. Like states, like land. Land is a very important issue. It borders on the welfare and well-being of Sierra Leoneans. So yes, we have the leverage, we have the latitude to approach the office of the president through the AG's office. We can do that. However, it also behoves the Bar Association to advise on illegalities or legalities as the case is. Now, what we have done as Bar Association is not a press release, it's a letter directed to the Permanent Secretary of the Ministry of Lands, Country Planning and the Environment. Now, if you are aware that the Permanent Secretary is the administrative head of the ministry, the minister is just a political head. So it means that as administrative head, he knows the administrative functions and other things about the ministry. So ministers will come and go. His Excellency may decide to change Dr. Sandy tonight. There will be another minister. You know, that has been, in fact, the land ministry has experienced the most turnover of ministers over the years.
You have the most reshuffled ministers.
Exactly. So the permanent secretary, that's why we are guiding the permanent secretary by our letter of the 6th of May. We are guiding the permanent secretary as to the route they should pursue, so that they can abandon this route that has already been pursued, that is causing chaos, alarm, and confusion, to such an extent, instability in the country. So the issue of land is not child's play. People take it very seriously. They have killed ministry officials in this matter. And as I mentioned earlier, even this issue, if not properly handled, has the potential to incite ill will and disaffection for the government itself. So land issues are not things you just get up and try to do
South
as
Africa is a
you
case
will.
in point.
Yes, South Africa is one. Even Uganda. Unfortunately, our constitution does not deal adequately with how land is acquired and those sort of stuff. But in other constitutions, like the Ugandan constitution, it tells you. So, for example, the land policy, national policy is saying that, where the constitution says that, I think it's section 5, that the sovereignty of the state is vested in the people of Sierra Leone. It should also say that sovereignty of the state and of land should be vested in the people of Sierra Leone. It's not vested in the government. So these are things we are saying. When you go to the provinces, they have a different land tenure system, and we have different laws that apply to them.
And in my view, honestly, this is my personal conviction. It may sound like a delicious irony where you have a law that actually prohibits the Creoles from holding land or country. Now, there is another in the capital city that is actually moving towards, dispossessing them from their land ownership title. So asking the question now, I am asking the question, where do you want to see these guys? Little wonder that we've now seen press release coming from the descendants of the 4 homogeneous group, the Nova Scotians, the Maroons, the liberated and Paul Kofi returnees, who they say they are naturally perturbed, dismayed, and shocked by the official statement of the Honorable Minister of Land. If you don't give the right to Creoles to actually own land, then you're still doing something within the capital city where they have a huge chunk of land ownership.
Okay.
What the question is moving towards, as your colleague did say, Kita Conte, the 1991 Constitution is a very fine document, but it ought to have been better.
Yes, I agree. And this is a disclaimer. Bar Association has not commented on that. So perhaps this is just a view for argument purposes or to make the program more lively. Now, yes, by the Provinces Land Act, Creoles are prohibited from acquiring or owning land in the provinces. Yes. Of course, many human rights activists, civil society organizations, and even the Bar Association have cried that law, that particular law down as discriminating, outright discriminatory. You know, because the provincials will come to Freetown and acquire lands. You know, nobody stops them. And so you can see the background from which the indigenous tribes are coming. Because originally Freetown And those areas that they mention in the press releases were bought for them. Were bought as pieces of land from the indigenous settlers, you know, from the King Toms, the King Nimbanas, you know, history will tell us. So those lands were actually bought by the British when those slaves were returned. So yes, they can claim it as their private land. Okay. However, we cannot say it's actually the ministry that will say which land is actually state land. We cannot authoritatively say that. So therefore, now you see the reason why it is very important that issues of this nature cannot just be handled by just a minister or a ministry.
Okay.
It's an issue of public importance or national importance. So therefore, you take it to the court where proper investigation is done, where an independent and impartial tribunal is seated to investigate these things, so that people would know that indeed, even if I'm dispossessed, I was given due process. I was heard, they investigated my title, I produced evidence, but perhaps government land is government's case is more strong than ours. Or better still, you can even take the compulsory acquisition position, as long as these people are adequately compensated. So all these unnecessary alarm and mayhem and confusion that is ongoing, to me, it's really, really uncalled for.
Okay, now you are the public face of the Bar Association. What will you give out to be the collective opinion of the bar with respect to this current issue? Well, I assume the Minister of Land is watching you, His Excellency, government officials are there. Looking at you. What could be your last remark?
Well, this is what we have done. What we have done is to guide the minister and the ministry in performing their function lawfully. Mind you, the Bar Association is not against the minister performing his lawful duties. The Bar Association is against the illegal manner in which it is done. So we have advised the permanent secretary of the ministry that in order to do land reclamation and repossession, seek court order, even to demolish structures on clear public or state land. You have to seek an order of court to do that. It is only the court that is mandated to.
Maybe this is lack of public knowledge that is driving people to actually take upon themselves to do the wrong thing. They will tell you, I'm not even aware as to whether it requires a public order, a court order for me to actually execute what I'm doing.
My brother, the common defense that
ignorance of the law.
It's no excuse, exactly. And for a ministry official or a ministry or government department or agent, of course, you don't have to say that. It makes mockery of the whole situation. That's why you have principal advisor to government, legal advisor to government. So if you want to embark on such very sensitive program or project that will not harm the government or your individual or your personality or person or the interest of other citizens, then do the necessary, seek court order, seek advice, and then you will be guided.
Okay.
So that's the position.
Okay. I want to thank you so much, La Israel Jah, for honoring this invitation, being part of this program today. Want to give the assurance to our viewers that if you miss a segment of these, of course, we are live on Star Television on the Facebook and also on YouTube. If you miss a segment of this, you will have the opportunity to have a repeat of it at exactly 11 tonight. My studio guest is a public relation officer for the Israeli Bar Association, where the Bar Association made written a letter to the permanent secretary with respect to for the forcible repossession of land purportedly deemed to be state land, where a number of accounts know that officials of that Ministry of Land, including the Minister of Land, supported by armed military personnel and police officers, have entered a number of pieces of parcel of land and have forcibly repossessed the same. This is a very dangerous path for our country. Till then, this is how I draw the curtain into this edition of the program. My name is Abdul Rahman Kamara. Have a wonderful day. Thank you so much, sir.
Star TV. Tell him mama, tell him papa, Star TV. Tell him sister, go tell him brother, Star TV. Don't forget your granny and the grandpa, Star TV. Yeah, the mama, 24/7, Star TV. For your games and sport, yeah, lele. Advertisement, yeah. Information, education, entertainment, stay glued to Star TV. #1 TV na saloon, oh Star TV. It don't come for you and me. Star TV. See on channel 21, mama. Star TV. On channel 21, baba. Star TV. On channel 21, yeah. Star TV.
This is Star TV on channel 21. Stay glued.
Take a. Yeah, look at. When I try on the table tonight.